Good afternoon, everyone. Welcome to our webcast, the Tennessee Criminal Law Legislative Update. Thank you for joining us. I wanted to let you know you can utilize the chat today, but just to make sure we get the presentation in, leave those questions for the end. And if time permits, we'll make sure to get those to you. So I'm going to jump right in and welcome Chelsea Curtis. Thank you for being here.
Thank you so much for having me. I'm Chelsea Curtis. I'm the Deputy Executive Director of the Tennessee District Public Defenders Conference, and I'm going to be going over all of the laws that passed the Tennessee State Legislature in 2025 that deal with criminal law. And if there are questions, feel free to drop those in the chat. I'm going to try to reserve hopefully 5 minutes at the end to answer questions, but there is quite a bit of material to get through, so I'm going to get on with it. All right. And first, I'll explain how I have my slides set up here. Obviously, the subject's in the title line, but you'll see up here on the right top corner is the effective date. So that's when the law takes effect. Most of these laws have become effective July 1 of this year, but some of them you'll notice are maybe January 1 of 2026 or the date that they actually got signed into law. So maybe like a random day between February and May. But that can be useful if you have a specific case that you're thinking of. And then obviously an explanation, but also in the bottom left corner is the public chapter number if you need to look that up. And then also in the bottom right corner, probably the most useful thing is the code sections that the law changes. All right, so let's jump right in with DUI laws, vehicles, and moving violation laws. And the first law I'm really proud of, this was something that the Public Defenders Conference actually worked on. And driving on a revoked, suspended, or canceled license used to be 8 points on a person's license, but now this law that became effective July 1, 2025 limits the points a person may be assessed on their record for driving on a revoked, suspended, or canceled license to 4 points. And so, as you all probably know, the Department of Safety, once you get 12 points on your license, that creates all these additional issues. So kind of gives people a few more chances to get their driver's license back before they run into more trouble. All right. Refusal, blood draws, and vehicular assault. So this law first alters the length of a term for which a person's driver's license may be revoked for refusing to submit to DUI testing during a traffic stop. And it also increases the amount of time a person's driver's license must be revoked for a first offense of an implied consent violation. And that's up from 1 year to 1 year and 16 months. But that does not become effective until January 1st of 2026. So be aware of that. Also permits a person to be charged with refusal to submit to a test, even when the refusal is subsequently followed up with a search warrant or other court order. So in prior law, there was an exception for refusal when a blood draw occurred later as a result of a search warrant. That is no longer the case. So just the refusal is going to end up being a violation. Third, a new test is introduced. An oral fluids test may be administered to a driver under the same circumstances as a blood draw, and that's also admissible in a similar fashion. However, there's no definition of what an oral fluids test is or who may administer it, but obviously thinking of it as like a spit saliva test. Lastly, the driver's license revocation periods are increased for those convicted of vehicular assault for a third or subsequent offense. So for a third conviction, the revocation period shall be 6 years. That's up from 3 years under previous law, or actually current law, because this doesn't take effect until January 1st of 2026. And then for a fourth or subsequent conviction, the revocation period goes up to 8 years, increased from 5 years. Right, aggravated vehicular assault and blood alcohol content. So this lowers the BAC threshold from 0.2% to 0.15% for vehicular assault and vehicular homicide. So essentially, if you have a vehicular assault and a BAC of 0.15 or more, and you have a prior DUI or BUI, that's going to now become aggravated vehicular assault. And then vehicular assault plus a BAC of 0.15 or higher and a prior is going to be aggravated vehicular homicide. So, yeah, these are going to be way stricter, and this is kind of a trend. The legislature has been going a lot harder on vehicular assaults and aggravated vehicular assaults lately. Right, big changes here to interlocks and indigency determinations. So for those of you who represent indigent clients, this is important. This removes the responsibility of the court to determine whether a person is indigent for purposes of payment for the costs associated with an ignition interlock device. It establishes that the state treasurer shall deem a person ordered to use an ignition interlock device to be indigent if the person is qualified to receive or is receiving SNAP, TANF, or state Medicaid on the date the person was ordered to use the device. So the clerk is now having jurisdiction over the person to provide the state treasurer proof that a person who has been ordered to use an ignition interlock device qualifies for one or more of those benefit programs in order to demonstrate the person is indigent. And so the person has to provide consent for the clerk to obtain such proof. And, it does, the trick here is that it says if they are qualified for. So even if you have a client who's not actually receiving SNAP-TAN for Medicaid, I think there's room for you to argue that they could qualify. Now, how successful you're going to be arguing that to the clerk's offices, I don't know, but I think there's room there to at least argue that. So don't give up if your client wasn't already receiving those benefits. You can try to fight that, I think. Ignition interlock appointments and military personnel. So this basically is kind of building in some leniency for active duty military members. So if they're deployed for more than 30 days, they can request, and they obviously have to also submit proof, a temporary tolling of the requirements, such as the usage period for the interlock. And that request has to be made to the provider and then submitted to the state, and then the state can approve or deny the request. It also just cleaned up like some language that needed to be cleaned up in the statute. And then if approved, the tolling would be for the number of days that the person will be on active duty or temporarily assigned to another station. But then once they return, they have 30 days to have the device calibrated, and then any usage period will resume counting. And if the period for which the service member will be deployed exceeds 90 days, then the device may be removed and then reinstalled upon return within 30 days. All right. Also dealing with ignition interlock appointments. Basically, this is extending a grace period. So a person is not in violation if they appear for calibration, monitoring, or inspection at any time the provider is open within 7 calendar days before or after the date of their scheduled appointment. So that's a pretty actually big grace period, which is nice. And then they may make an appointment for calibration, monitoring, or inspection within the 7 calendar day period before or after the original appointment. But the calibration, monitoring, or inspection must be completed within the 7 calendar day period before the original appointment for C1B1 to apply. So this is all, as you all know, those of you who do any kind of DUI work, Title 55 is kind of a nightmare. This is kind of making it even more nightmarish, but if you have clients that this affects, just be sure to read this carefully because it is a little bit confusing. But do know that the purpose of this was to institute a kind of grace period. All right, further changes to clarify that during the last 120 days of the usage period, a person may not tamper with, circumvent, or attempt to start a vehicle with a BAC equal to or in excess of 0.02%. So it's equal to 0.02, not just in excess of 0.02. That also applies to failing a rolling test. A person is now eligible for reinstatement if they've had a noncompliance issue, if the only noncompliance was related to the calibration, monitoring, or inspection of the device, and then in which case a court can order reinstatement. So that's nice. If all the other requirements are satisfied, which includes paying fees, then there are no other revocations or suspensions on the record. The Department of Safety shall reinstate the license. All right, illegal aliens and driver's licenses. There are new sections added to Title 55, Chapter 50, Part 3 to address driver's licenses issued to undocumented persons in other states. So if another state decides to give an undocumented person a driver's license, basically the state of Tennessee Department of Safety has to create and maintain a list of driver's license classes in other states that are provided to undocumented persons and would then be invalid in Tennessee. So this is really important to let your clients know. If you know that they're driving around with another state's license that would not be valid in Tennessee, just let them know that it's not valid in Tennessee. And so this applies to licenses issued exclusively to illegal aliens and containing a mark or designation that allows it to be easily distinguishable from normal licenses issued to citizens and undocumented persons in those states. And violation is a Class B misdemeanor. All right, impersonating a rideshare or taxi driver, it's now a Class B misdemeanor to impersonate, Uber, Lyft, or a taxi, and that becomes an E felony if the offense is committed during the commission of a separate felony. And it clarifies that if someone steals a taxi and commits the offense, the owner of the taxi is not liable. Okay, blocking traffic. This is aimed at Ubers and Lyfts, I believe, and those kinds of things. It creates an offense for blocking or impeding the normal movement of traffic for the purpose of soliciting, negotiating, or consummating an employment transaction with a person standing on or in proximity to the street or highway, First offense is a warning. So, I guess this is for the police who are telling Ubers to move out of the way. After the second warning, basically, or offense, it's a Class C misdemeanor. If the vehicle that's blocking or impeding traffic causes or contributes to a motor vehicle accident, then it goes up to a Class B misdemeanor. All right, catalytic converter theft. This also authorizes incarceration for the offense of possession of a used detached catalytic converter by an unauthorized person. It was previously a fine-only punishment, and I'll tell you that was because the fiscal note was too high whenever they tried to incarcerate people for this because there were so many of these offenses happening. But I guess they found the money to fund this bill in the last legislative session. So now you can also be put in jail for this. All right, digital driver's licenses. We are moving into the future here. And so there apparently are talks of developing a uniform electronic driver's license system. That has not happened yet, but this is kind of setting up the framework for that. Clarifies that digital driver's license is evidence for ID or other purposes to a law enforcement officer, seller of alcohol, or other persons. Can't use it for voting, but any of those other purposes you can. And just because a person participates in the digital license system doesn't mean that they can't also use a physical license. No entity can require or provide preferential treatment for one or the other. So once this comes online, I think this will be probably good. People can just pull up their licenses on their phones if they want. All right, electronic vehicle registration documents adds a new subsection which permits a person to submit an electronic form of their vehicle registration to law enforcement. It has to be clear enough for an officer to read, and the image complies so long as the officer does not believe it to be fraudulent or inaccurate. So you can show your registration as a picture on your phone so long as the officer believes you. That's wide open, so do with that what you will. All right, pointing laser pointers at vehicles is a Class B misdemeanor. Just be aware of that. Counts for cars, boats, planes, or other motor vehicles. Helicopters are included in that as well. All right, license plate flippers. A vehicle found with a license plate flipper may be impounded or seized by law enforcement as evidence. However, the owner of the car has the opportunity to promptly remove the flipper if it can be done safely to avoid the seizure and impoundment of the vehicle. The flipper will be seized in that circumstance, and the fees for the impoundment are the responsibility of the vehicle owner. All right, moving on to civil rights and searches. All right, restoration of voting rights. This was actually a big bill, but it changes the process for returning the right to vote for felons, whether the prior felonies were in Tennessee, another state, or federal. Each subdivision is amended to clarify that the right of suffrage may be returned in circumstances in which Tennessee law permits it. It does not require a full pardon or full restoration of citizenship. This controls who may seek to have their suffrage rights restored. A person may petition the circuit court of the county in which they reside or where the felony conviction occurred. And a petition may only be sought in the following circumstances: when a person is pardoned upon successful completion and discharge from custody by either service or expiration of maximum sentence imposed for each felony, or if the Board of Parole grants a certificate of final discharge from supervision or the equivalent discharge by another state, the federal government, or a county correction authority. And then the following offenses are never eligible. All these are pretty standard. And this all depends on the date and everything, but if you have an offense committed after 2006, it includes this, any felony that involves interference with government or bribery, etc., or any sexual offense or violent sex offense after that date, that's a felony. Let's see. Yeah, and a lot of these, you're going to have to really dig in the weeds here if you have clients that were pre-2006, because there were a lot of different cutoff dates for these certain offenses and things. But importantly, the petitioner has the burden of proving by a preponderance of the evidence whether his or her or whether he or she is eligible to have their suffrage rights restored. If there's no objection by the prosecutor within 30 days of the filing of the petition, the court can make a ruling without a hearing. The cost of the burden of the petitioner unless they're found indigent. And the court can rule all rights restored, suffrage, firearms, or they can restore partial rights. So as any of you who are familiar with restoration of rights know, the firearms piece has been really problematic because the federal law a lot of times blocks felons from having their firearms rights restored. And so that was creating issues with people getting their voting rights restored. In short, this bill separates those out. So now in Tennessee, you can have someone have their voting rights restored without having their firearms rights restored. So that's kind of the summary of that. And I'm happy to send over a PDF of all of this information at the end of this to all of you if you're interested. But that voter restoration one is fairly complicated, but that's kind of the quick summary of that. All right, and then this big piece of legislation here we're going to talk about next deals with civil rights, littering slash trespassing, and show me your papers and more. And so this law was based on, if you'll remember, Nashville on Broadway got a lot of press because there were white supremacist groups on Broadway handing out pamphlets. And so this bill was kind of sold at the legislature as trying to prevent that type of behavior. And so this expands the offense of civil rights intimidation to include littering or trespassing upon the real or personal property of another person with the intent to unlawfully intimidate another from exercising any right or privilege secured by the Constitution or state law, or because that other exercised any right or privilege secured by the Constitution or state law. And litter is defined as dropping, placing, or throwing garbage, refuse, rubbish, unsolicited flyers, or other waste material onto any public or private property without permission. And that's a Class A misdemeanor. Also permits an officer to ask a person to identify himself if the officer has reasonable suspicion to believe the person is violated or is violating a state law or city ordinance. Pursuant to this reasonable suspicion, the officer may ask the person's name verbally or ask them to provide a name via other means. Giving a false or fictitious name to a law enforcement officer who's lawfully detained or arrested a person is now a Class C misdemeanor. I actually think that's favorable from the defense perspective because the C misdemeanor is lower than um, than providing, false ID under other parts of the code. So that's probably good. And then failure and ability to produce a physical form of ID or driver's license is not a violation. It's just if you give the false name. Also creates an offense for intentionally approaching within 25 feet a law enforcement officer after the law enforcement has ordered the person to stop approaching or to retreat, and the officer is lawfully engaged in the execution of their official duties involving a traffic stop, active investigation, or an ongoing and immediate threat to public safety. I believe there's already a lawsuit filed about this. So definitely look into that if you have a client who's charged with this. It's a Class B misdemeanor. There's an affirmative defense that the lawful order was not received or understood by the person and was not capable of being received or understood under the conditions and circumstances that existed at the time of the issuance of the law enforcement officer's order. So there's lots of room to kind of fight that if you have someone charged with that. Creates an offense for transporting another person in the cargo area of a box truck. That's a Class B misdemeanor. It defines what a box truck is. But essentially, if you pile guys in the back of a U-Haul, that's going to be Class B misdemeanor. All right. There is also, this is still in the same piece of legislation. They created an offense for placing a sign, signal, or marking over a highway, or to affix a sign, signal, or marking to a bridge, overpass, or tunnel without written authorization from the entity that maintains the highway, bridge, overpass, or tunnel. That's also a Class B misdemeanor. In this same piece of legislation, it created new subdivisions which permit a law enforcement officer to make a warrantless arrest and take a person into custody for a misdemeanor not committed in the law enforcement officer's presence. So this is a huge departure from previous law. And so, this is probably going to create some interesting problems since they can now do these warrantless arrests for misdemeanors that were not in their presence. All right. This same law also requires an officer to provide the reasoning why a citation was not issued relative to specific statutes regarding such whether an officer makes a physical arrest, whenever an officer makes a physical arrest for a misdemeanor. So they do at least have to provide reasoning why they did not just issue a citation. Provides that an officer who, on the basis of facts reasonably known or reasonably believed to exist, arrests a person for a misdemeanor in lieu of issuing a citation with civil and criminal immunity from false arrest, false imprisonment, or unlawful detention. So they do have that immunity built in as well. Yeah. So that bill, that was a huge piece of legislation, did a lot. And as you'll see, there are probably some pretty far-reaching aspects of that go beyond kind of the behavior that was the bill was said to be aimed at. All right, next we're going to talk about limitations to school searches. So it clarifies that if a principal decides the search is necessary, then only the SRO, the school resource officer, the school security officer, or a trained school administrator may perform the search. If the search is to be made of a student, their actual person, not just their property, who's under 18, then the parent or legal guardian must be notified by the school principal. Now, interestingly, this doesn't say that they have to be notified before. So do with that what you will. Also creates an orientation and training program for LEAs pertaining to student rights and searches. So school administrators must complete this training program prior to be permitted to conduct any searches mentioned above. Right, search warrants of service providers. This is also a big shift from previous law. But it prohibits an electronic communication service provider from informing the account holder or any other person not authorized to be notified of the service of a search warrant on the provider or the contents of the warrant served if it pertains to an investigation into the allegation of sexual exploitation of a child. So basically, if the police are investigating sexual exploitation of a child and they want to, subpoena Facebook or Gmail or, whoever, then that service provider can't let the account holder know um, for at least 90 days. And there is a way that the law enforcement can request an additional 30 days to make it 120 days. So again, that's a pretty big departure from previous law. All right, next we're going to talk about bail, sentencing, GPS, jurisdiction, and procedure. All right, venue for bond violations. This establishes that the venue for a bond violation is in the county in which the conduct constituting a bond violation occurred. If one or more elements of an offense are committed in more than one county, then venue is in any county in which an element occurred. So hearsay in bail hearings. This law permits a magistrate to consider hearsay evidence in determining whether to set bail or how much. The evidence must be found by the magistrate to be reliable if the defendant has a fair opportunity to rebut any reliable hearsay evidence considered. And so my understanding of this is mostly aimed at criminal histories. So basically magistrates can consider criminal histories and, CJIS or NCIC is going to be found to be probably reliable hearsay. Right, DNA from convicted persons. This new law requires a defendant's biological specimen to be gathered within 30 days of sentencing, or if the defendant's term of incarceration is less than 30 days before the completion of the term of incarceration, if they're required to register as a sex offender. Also authorizes a law enforcement agency to submit to the TBI a lawfully obtained biological specimen within its control from a deceased offender who was previously convicted of a qualifying offense, regardless of the date of conviction. It also requires law enforcement agency to submit to the TBI the biological specimen of an offender convicted of a qualifying offense who dies while incarcerated, regardless of date if their specimen had not been previously submitted. So essentially, the TBI ran this bill. They're trying to clear cold cases by getting deceased inmates' DNA, but it's also tightening up and making sure that people's DNA is collected because, as you all know, it was already in law. That felons were supposed to have their DNA collected, but there were for a lot of reasons that wasn't being done. And so the TBI had this bill to basically kind of make sure that the jails are doing that. All right, work release and GPS expense requires that if a prisoner is released for paid employment, then any expense of electronic monitoring has to be taken out of their pay and paid to the electronic monitoring service provider. Current law already required if unpaid work was done, the entity which utilizes the unpaid labor has to pay for the monitoring. All right. Also, on the note of GPS monitoring, if a defendant who's ordered to wear a GPS device as a condition of pretrial release fails to pay for it, or the costs associated with the victim's cellular application or electronic receptor device, the electronic service provider has to notify the court in writing within 5 days of the arrearage. And then within 10 days of receiving such notice, the court has to immediately schedule a show cause hearing to be held within 30 days. And then the court is authorized to either revoke the defendant's bond and incarcerate them, allow the defendant to immediately bring the payments current and continue their pretrial release, or determine whether an alternative funding source is available to help pay for it. And that's kind of, in my understanding, only going to be a real option in the more metropolitan districts and counties. All right, GPS monitoring, again, authorized future costs, specifies that local governments are not responsible for the costs in such cases unless local government has an established fund for that specific purpose, and establishes that an electronic monitoring provider is not required to continue to provide service when they're not being paid. Okay. And next, we're going to talk about this really weird bill that deals with mandatory cognitive behavioral training, not to be confused with cognitive behavioral therapy, which is kind of a recognized thing. This mandatory cognitive behavioral training is more like a life coach kind of situation. So the lobbyists for one of these companies were successful in getting this passed, and it mandates that a person convicted of a Class A misdemeanor in General Sessions Court is required to complete a cognitive behavioral training program unless the court deems it inappropriate. So any Class A misdemeanor conviction coming out of Sessions Court is mandatory that they have this cognitive behavioral training. And so if it's required, the training has to occur after incarceration. The defendant's responsible for the cost. The course cannot cost more than $100. Any failure to complete the course within the time set by the court is contempt. So punished as contempt. It can't be like a probation violation or anything like that. And then this law also defines what the course is and who may administer it. But I've been hearing anecdotally that a lot of judges just kind of think this is stupid and are just deeming it to be inappropriate. If you're interested in learning more about that, you can definitely reach out to me. Have my email at the end of the presentation because I can show you the websites where all these courses are. And it is kind of not probably very scientific. All right, mandatory mental health evaluations for certain offenses. So this law mandates a mental health eval for defendants convicted of domestic assault, child abuse, ag child abuse, cruelty to animals, or ag cruelty to animals. The evaluations are to occur prior to sentencing, but this only applies to first-time offenders. If there was already a previous mental health eval, then another is not required. If the evaluation determines that the convicted person needs mental health services, then the court may include the services as part of the sentence, but they're not mandated to include it. The person who's evaluated is responsible for the cost of the evaluation unless they're deemed indigent. All right, expiration of misdemeanors and mental health circumstances. This extends by 1 year the time period after which any misdemeanor charge must be retired for a defendant who is deemed incompetent to stand trial if that defendant remains hospitalized on that date. So basically, if somebody's hospitalized the whole time, it can be 2 years from the date of the arrest before they can have the charge retired. Also requires the chief medical officer in charge of such a defendant whose charges have been so retired to notify the court when the defendant is discharged into the community and to provide the court and the sheriff with an outpatient treatment plan that accounts for the safety of the community. There's not really any teeth to that, but they do technically have to notify them. So be aware of that. All right, next we're going to talk about this bill dealing with firearms, probation, and parole. So the definition of a machine gun was added. The penalty for possession of a machine gun is raised to a C felony. That's up from an E, so quite a few classifications up. Removes an affirmative defense for ornamental possession of a machine gun, so not cool to have one on display even. Clarifies that for purposes of unlawfully possessing a firearm, after having previously been convicted of a felony crime of violence or a felony drug offense, it's also unlawful to possess ammunition for a firearm. That's really important change. And the same is true for possession of handgun ammunition if one has been previously convicted of a felony. So really, if you have, any clients who've been convicted of felonies, it may be prudent to kind of send out letters to let them know, hey, ammunition is not even okay anymore to have in your possession. All right, probation adds assault involving the use or display of a weapon from within a motor vehicle to the list of non-probatable offenses. So they're really going after road rage in the legislature as well. All right, parole, mandatory 100% sentence adds aggravated assault in which a firearm is used or displayed from within a motor vehicle to the list of sentences, which are to carry a 100% sentence with no release eligibility. So you may have heard about, truth in sentencing. They're adding to all of these lists of offenses that are 85 or 100%ers. And so ag assault in which a firearm is used or displayed from within a motor vehicle is now a 100% offense. Right, circuit or criminal court jurisdiction and protection orders. This is specific to Shelby County. I'm not sure if we have any Shelby County folks on here, but it authorizes criminal court in Shelby County or any circuit court in the state exercising criminal jurisdiction to process matters related to orders of protection when the criminal court is hearing a criminal matter involving the victim of domestic abuse, sexual assault, or stalking. Specifies that such authorization does not extend to those courts for matters relating to child custody, visitation, or support. I should say, this bill was aimed at Shelby County, but they actually opened it up so other courts can opt in if they want to, but I'm not aware of any other circuit or criminal courts opting into this besides in Shelby County. All right, use of juvenile court records in adult court. This law expanded when the disposition of a child and evidence adduced in the juvenile court may be used against the child in any other proceeding before or after reaching the age of majority. So it adds that these records may be used in pretrial reports used to set bonds if the juvenile court adjudication occurred within the last 5 years. So importantly, if you have a client who's, say, 20 years old being arrested, then basically their juvenile record can be seen by a magistrate or a judge if it was within, the last 5 years. So that's a big departure from previous law. Also requires in determining the amount of bail necessary to reasonably assure the appearance of the defendant and the public safety, a magistrate to consider the defendant's prior juvenile record. So actually the magistrate has to consider that prior juvenile record. All right, error quorum nobis eligibility. This was a Tennessee Innocence Project bill. It expands the writ of error quorum nobis to include cases in which the defendant entered a guilty best interest or no contest plea. So this essentially vacated the Frazier versus Tennessee decision. So this is hopefully helpful. All right, next we're going to talk about sex offenses. All right, the penalty for aggravated sexual battery is increased to a Class B misdemeanor. This law adds that if the victim was under 18 or mentally defective, incapacitated, or physically helpless at the time of the offense is still a Class B, but the person shall be sentenced as a Range 2 offender and may be sentenced as Range 3 if they're actually Range 3. Right, classification of sex offenders requires the TBI to classify persons on the sex offender registry based on whether the person is a sexual offender, violent sexual offender, or violent juvenile sexual offender, and whether the offender is an offender against children. The TBI may rely on investigation reports, the U.S. Attorney or DA or other prosecutorial entity, court records, or other credible information to classify the type of sex offender they are. And it requires the TBI to notify the offender of their classification. My understanding is that they were already doing this, but this just put it into statute. All right, unlawful exposure clarifies that a person commits the offense of unlawful exposure by distributing a private, intimate image of another identifiable person with the intent to cause emotional distress, regardless of whether the person who distributes the image was a party to the original agreement or understanding that the image would remain private. So this is, obviously dealing with passing on, nude photographs or something like that. Like just because you're not the original person that the photograph was shared with, you're still on the hook if you're further distributing the image. All right, Voyeurism Victims Act adds the definition of disseminate to mean to transfer, publish, or otherwise make available photograph of intimate areas of another. Adds a new subsection which tolls the statute of limitations for the period of time in which the defendant conceals the crime until the victim discovers the crime. Adds the definition of observation without consent of the victim, an unlawful photography victim, and clarifies that in domestic relationship scenarios, a domestic partner who's subject to observation without consent or unlawful photography may claim domestic abuse as a result of those acts. So a person who's an alleged victim of observation without consent or unlawful photography by a significant other can then qualify to file for a petition alleging domestic abuse or file for an order of protection. And so you may have heard in the news, there was a big case in Nashville where a guy had a hidden camera in his bedroom and had kept videos of, having sexual relations with various women. And one of them later discovered it, but a lot of the women were outside of the statute of limitations. And so basically this bill sought to put a toll on the statute of limitations for those kinds of offenses. All right, unlawful photography penalty creates an offense for photographing the intimate areas of an individual without consent or the consent of a minor's parent or guardian and was for sexual gratification or arousal. Makes it a Class E felony, but it's a D if the victim was under 13. Clarifies that a person has a reasonable expectation of privacy regardless of the location of the individual if the photo is taken in a manner that would offend or embarrass a reasonable person and the photo depicts areas of the person's body, whether clothed or not, that would be visible by ordinary observation, but for the embarrassing manner of the photography. The unlawful photography statute is also becoming a nightmare because they're tweaking it every year. So if you have somebody charged with this, just be sure to look at the offense date and make sure you know which version of unlawful photography was enacted at that time. There's a lot of different language, and some parts of it are a reasonable person and some parts of it are what that individual person would find embarrassing. So just be really careful and meticulous when you're looking through the statute if you have one of these cases. It's a Class E felony if a minor under 13 was used to facilitate certain types of violations. And it raises the dissemination of photos of intimate areas to a Class C felony. Further clarifies that for an offense under this section, the defendant can be under 13 or the defendant at the time was in a position of trust or had supervisory power over the victim and used that position of trust or power to accomplish the act. And for certain kinds of violations, the person has to register as a sex offender. All right, statute of limitations and child sex offenses extends the time period within which a prosecution of sexual offenses against minors may be commenced. So for offenses committed between July 1, 2019 and July 1, 2025, statute of limitations is 25 years after the alleged victim becomes 18. For offenses on or after July 1 of this year, it has to commence within 30 years. So they've extended that statute of limitation by 5 years. And so obviously not going to see the benefit of that for quite some time. All right, deepfake images. There is a new offense for disclosing or threatening to disclose or solicit the disclosure of an intimate digital depiction with the intent to harass, annoy, threaten, alarm, or cause substantial harm to the finances or reputation of the depicted individual, It's a Class E felony, or with actual knowledge that or reckless disregard for whatever such disclosure or threatened disclosure will cause physical, emotional, reputational, or economic harm to the depicted individual. It's a Class C felony in the case of a violation in which creation, reproduction, or distribution of the intimate digital depiction could reasonably be expected to affect the conduct of any administrative, legislative, or judicial proceeding of a government agency, including the administration of an election, or facilitate violence. So yeah, they're having to kind of come up with laws dealing with AI and deepfakes and those sorts of things. So expect to see more laws like this passing in the years to come. Right, tech and software used to create child porn. So there's now an offense for knowingly possessing, distributing, or producing any tech software or digital tools designed for the purpose of creating material that involves a minor in sexual activity or simulated sexual activity that is patently offensive. So possession of this kind of software or digital tools is an E felony. Distribution of this kind of software or tools is a C. And if it's produced, if you're making software or digital tools, it is a Class B. All right. List factors which must be considered in determining whether the tech or software is designated for the purpose of creating child porn content. So statements by the defendant concerning its use can be used. The existence of material that includes a minor engaged in sexual activity or simulated sexual activity that is patently offensive, it's in the defendant's possession, that can be used. Instructions concerning software or technology's use, descriptive materials that come with the tools explaining or depicting its use, the manner in which the technology, software, digital tools were advertised or offered when obtained by the defendant, the existence and scope of legitimate uses for the technology, and then expert testimony concerning the use of technology. So all of that can be considered. All right. Next, we're going to talk about changes in the law regarding witnesses. So authentication of child interviews. This permits a forensic interviewer, in addition to the child, to authenticate a recording of a forensic interview with a child. Current law only permitted, or excuse me, I should say previous law, because this already took effect in April. Previous law permitted the child to authenticate. The child must still be available for cross-examination, however. This prohibits an interview from being deemed inadmissible solely because the interviewer was employed by a federal agency and conducted the interview in the course of a federal crime investigation, or because the interviewer is employed by a child advocacy center and the center didn't have a signed memo of understanding and working protocol among all the relevant county and municipal law enforcement agencies, provided that the center did have such arrangement in place with DCS and any DA's office. So what you need to remember from the defense perspective is that the child still has to be made available for cross-examination, but the intent of this was to make it a little less stressful on the child, I guess. Right. Also, we're going to talk about witness dogs. So courts are permitted to allow a certified facility dog to accompany a victim or other witness while testifying in court. The motion to use the dog must be made prior to the testimony by the party seeking to use the dog. And if the court permits it, the dog has to be accompanied by a certified handler, has to be outside the presence of the jury. The handler has to be present in the courtroom and within view of the witness stand during the testimony. There's also supposed to be a jury instruction on the presence of the dog and the intent not to prejudice any party prior to testimony. Yeah, this is a lot of work. So I hope that this, is being used judiciously, but just be aware that that's out there and theoretically allowed. All right, next we're going to talk about assaults, threats, dangerous felonies, and violence. All right, robbery is now explicitly a crime of violence. So I think we can blame that on the Public Defender's Appellate Division, who litigated a case too well. But State v. Curry had held that when a defendant is charged with possession of a firearm after having been convicted of a felony crime of violence based on a prior robbery conviction, jury instructions should inform the jury that the state has alleged a prior robbery conviction as a felony crime of violence, inform a jury of essential elements of a robbery, and explain to a jury that it must unanimously find that the prior robbery was in fact committed by use of violence before it can find that the robbery conviction is a felony crime of violence. The legislature decided to say, no, forget that. It's just robbery is a crime of violence, period. All right, armed dangerous felonies. This whole list has been reorganized and added to. It adds that a lesser included offense of the predicate dangerous felony named in the indictment or presentment is included in the indictment or presentment by implication if the lesser included offense is a dangerous felony. So here is the new updated list. And as you'll see, any attempt to commit a dangerous felony is also included. And then also a felony involving the sale, manufacture, distribution, or possession with intent to sell, manufacture, or distribute a controlled substance or an analog is also included. All right, next we're going to talk about racketeering and dangerous felonies. Adds new offenses which are to be considered state RICO offenses. So carjacking, organized retail crime, in possession or employment of a firearm during the commission of a dangerous felony. Right, next, harassment. This expands the definition of communicate in the harassment statute. So the highlighted words are new. So now communicate means contacting a person in the physical presence of the person in writing or in print or by telephone, wire, radio, electromagnetic, photoelectronic, photo-optical, or electronic means. It includes verbal and nonverbal communications, text messages, flyers, faxes, email, instant messages, images, videos, sound recordings, voice recordings, or intelligence of any nature sent through or posted on social networks, social media, or websites. So it's just really broadening what communicate means with regards to harassment. All right, threats of mass violence and posting information to threaten. This is another place where the code is getting really messy because they keep tweaking it every year. I do think there's going to be a concerted effort in 2026 to kind of clean this section of code up because right now there are kind of two different ways that a person can be charged with the threat of mass violence. And I'm not going to get too in the weeds on that, but just if you have someone charged with this, just be sure to be very diligent when the statutes. So this law adds the definition including mass violence as an act that a reasonable person would conclude could lead to the imminent serious bodily injury or death of 4 or more persons. It's a Class E felony to knowingly, by any means of communication, threaten to commit an act of mass violence, and the threat causes another to reasonably expect the commission of an act of mass violence. It's raised to a Class D if the threat is on the property of a school, church, or government building at a live music event, if the defendant has one or more priors for making these threats, or if the defendant takes a substantial step towards the execution and engages in preparatory actions. In addition to any other penalties, restitution may be ordered for damages incurred as a result of the threat. And as you can imagine, something like a live concert venue restitution could really add up there. All right, this bill also created an offense for posting on a publicly accessible website the phone number or home address of a person with the intent to cause harm or the threat of harm to an individual or their family. So this is like the anti-doxing bill. Class B misdemeanor for posting the information, and it's a Class A misdemeanor if actual harm results. So harm here means bodily injury or damage to property. Right, threat to a participant in a judicial process. So rewrites 3916.510A. Person commits an offense who harms or threatens to harm an individual involved in the judicial process or a family member of such person with the intent to impede, intimidate, interfere with, or retaliate against the individual in connection with the individual's participation in the judicial process. So this defines who is a family member. But then for those of you in private practice, I hate to say it, but you guys are not included in the definition of an individual involved in the judicial process. Weirdly, public defenders and our employees are. But if you are in private practice, you are not. So if you guys want to be included in that list, you might get together and run a bill or something. All right, human smuggling and trafficking. It's promoting the petition of a minor to the definition of a human trafficking offense and adds a new definition of organization, which permits the attorney in any state court. And I am aware that the AG is, trying to go after, hotel chains and things like that who don't kind of do due diligence and identifying trafficking situations, things like that. It also creates the offense of human smuggling. And human smuggling is knowingly transporting an individual with the intent to conceal the individual from law enforcement or federal immigration officer when it's known that the individual has illegally entered or remained in the U.S. or intentionally conceals, harbors, or shields from detection, or intentionally induces or encourages another to conceal, harbor, or shield from the detection if the individual knows that the person has illegally entered or remained in the U.S. I also believe there's litigation around this right now, if I'm not mistaken. I think some of these nonprofits are litigating this to kind of make sure that they're not falling under this offense because it is an e-felony. All right, also defines harbor as providing shelter, concealing the whereabouts of an individual whom the person knows has legally entered or remained in the U.S. That's as determined by ICE or Homeland Security. Attorneys are exempt if they're providing bona fide legal advice, as are healthcare workers if providing healthcare services at a licensed healthcare facility. I will say, as public defenders, we made sure to get that added in, that attorneys are exempt for giving legal advice. Aggravated human smuggling is smuggling, it's human smuggling when the victim was less than 13 years of age. That's what aggravated human smuggling is, and that's a Class A felony. Right, impeding a protection detail. This creates an offense for intentionally impeding or obstructing a member of a protective detail. So, the governor, the chief justice, speaker of the House, lieutenant governor, they all have these protective details. It's an offense to impede the ingress, egress, or movement about a space. That would be a Class A misdemeanor one in this circumstance threatens the safety or security of the protectee while preventing movement, it's a Class E felony. It's also an offense to intentionally refuse to vacate an area in which a member of the protective detail has restricted access to maintain safety or security of the person protected, and that kind of offense is a Class E felony. All right, moving on to children, juveniles, and domestics. All right, the Protect Tennessee Minors Act amendment. And so what this does, the existing law had defined what was harmful to post on a website that did not use age verification. This could be a company or an individual. It's a Class C felony if you post something that's harmful and you don't use age verification. Prior law defined what is presumed to be harmful or obscene. This law expands what's harmful or obscene to a minor to whatever the state can prove and that the jury finds is harmful. So, I mean, this is just super, super broad. So I'm expecting to see some litigation in that area at some point. All right, Persistent Domestic Violence Registry, also known as Savannah's Law. This is something that has been in the works or that had tried to be passed for years and years, and they finally got it passed. So now the TBI has to create and maintain a persistent domestic violence registry. And so a persistent domestic violence offender is a person who's been convicted of an offense committed against a domestic abuse victim and has had at least one prior. It doesn't matter if it's the same or a different victim. Upon proof of prior convictions, the court is to order the defendant to register as a persistent domestic violence offender. They have to pay a $150 registration fee for the privilege. And then they can require removal upon certain milestones. So after 5 years of the most recent conviction, if there was only one prior, 7 years for two priors, 10 for three, 20 years for four or more priors. Effective January 1, 2026. And this applies to persons convicted of domestic assault for an offense that was committed on or after that date, provided, however, that a prior conviction is not required to occur on or after that date. So, also may be prudent if you have former clients or current clients who are convicted of domestic assault to let them know if they get another one that they're going to, probably wind up on this registry. All right, bullying by juveniles, new penalties and penalties involving driver's licenses. So this enhances the penalty for a minor who communicates or posts pictures that they maliciously intend to be a threat to another and that a reasonable person would perceive as a threat, to include the suspension of that minor's driver's license for 1 year, in addition to any other existing penalties. Clarifies that if a juvenile is found delinquent for bullying or cyberbullying, a restricted license may be issued for the juvenile if they've not been previously adjudicated delinquent for bullying. The restrictions limit driving privileges to work, school, church, but not any social or extracurricular school activities. So school sport would not count. All right. Child neglect and economic disadvantage. It establishes that economic disadvantage of a parent or guardian alone is not grounds for termination of parental rights. Specifies that neglect does not exist solely on the basis of economic disadvantage either. Definition of abuse. Most of this act doesn't apply to criminal defense and it pertains to child custody matters. However, there's one section that expands the definition of abuse relative to domestic relations to include acts inflicted directly by the offending party or indirectly through a third party, including but not limited to a family member, friend, significant other, or coworker on behalf of the offending party. So basically, abuse is expanded if the person's using a third party to kind of commit the abuse. All right, the child abuse definition is also expanded to include when a person under 18 witnesses either the abuse or domestic abuse of another child in their immediate family or household. So now if you have, a client abusing one child, if there's another child in the household under 18, basically there's now going to be 2 counts, one for each child, the child suffering the abuse and then the child witnessing it. All right, child abuse penalty. Also enhances the penalty for a person who commits child abuse by knowingly treating a child under 18 in such a manner as to inflict injury, from a Class A misdemeanor to a Class E felony. So that's a big, big change. All right, child abuse and fentanyl clarifies that if a child is placed in imminent danger of death, bodily injury, or physical or mental impairment because of the unlawful exposure to fentanyl or any of its analogs or derivatives, it's a Class E felony. If the child is 8 years old or younger, the penalty is a Class B. This is like the existing law for exposure to meth, but with higher penalties. All right. Approved juvenile detention facilities. I'm not going to spend time on this because this was really limited to Shelby County. About 10 minutes left, but if you are interested in that, I can definitely send out more information. And we're going to get to our final section here. This is the miscellaneous section dealing with drugs, animals, theft, and corpses. So there's this really weird piece of legislation that all in one dealt with simple possession of fentanyl, corpses, and domestic assault. It's kind of like an overdose bill. The first section of it, dealing with simple possession, created a mandatory minimum of 30 days incarceration at 100% for possessing any amount of fentanyl or any of its derivatives or analogs. The person can still participate in drug or recovery court, but only after the mandatory 30 days. So that treatment can't be part of that 30-day minimum. Any person arrested by a law enforcement officer for possession of any amount of fentanyl or analog or derivative is not to be issued a citation. So they have to be physically arrested, and then they're going to end up with this 30-day mandatory minimum. All right. The second part of the bill deals with domestic assault and protection orders. It authorizes a petitioner to file for a lifetime order of protection in criminal court. That was kind of randomly thrown in. Also deals with disturbing corpses, so expands the offense of removing or disturbing a body or other articles at a scene of death to include the body, clothing, personal effects, or weapons of, at, or near any person who's died or reasonably appears to have died from a drug-related overdose. It's now an offense to touch, disturb, move, or remove the body, clothing, or personal effects of that person. However, there is an exception for a person that administers naloxone or any other opioid antagonist to a person who's experiencing a drug-related overdose. So if you're, trying to help them and revive them, that's not going to be, an issue. All right, selling cannabinoids to a person under 21. Basically, just know that that's a Class A misdemeanor, mandatory minimum 48 hours. Yeah. Opioid testing equipment. This was already existing law, but it was due to sunset, but they extended it. So now this is a permanent law. So opioid testing equipment is not to be considered drug paraphernalia unless it's being used to commit an offense. Right, organized retail crime adds an additional circumstance in which a person may be charged with organized retail crime and enhances the punishment one classification. It's punished as a theft or value of property if a weapon was used or if there was destruction of property by the accused in the commission of the offense. So these additional circumstances are added if you knowingly remove, destroy, deactivate, or evade any component of anti-shoplifting or inventory control devices, if you knowingly activate or interfere with a fire alarm system during the commission of the offense, if you knowingly use an online marketplace, so like Facebook Marketplace or social media platform, Instagram, something like that, to coordinate a meeting with one or more individuals to sell, barter, or trade stolen merchandise for monetary or other gain. That actually really does broaden up like what is organized retail crime. So I think that's probably going to be a big issue. You're going to see a lot of that, I bet. And then knowingly returning stolen merchandise or counterfeit merchandise to a retail merchant. It's also going to be organized retail theft. Receiving or purchasing or possessing retail merchandise for the purpose of sale or resale, knowing or believing the merchandise to be stolen. So if you're kind of knowing or should know that it's fenced, that's a problem. Knowingly using any artifice, instrument, container, device, or other article to facilitate the commission of an offense under this subsection. Knowingly using a device, apparatus, including but not limited to anything that could be, an automated teller machine. So basically these self checkouts, things like that. Unlawfully capturing, recording, or transmitting, magnetic strips from credit cards or chips, anything like that. Also knowingly possessing or controlling 10 or more fraudulently obtained access devices, including gift cards with the intent to defraud another. All right, so yeah, big expansion of organized retail crimes. And then also animal fighting has been added to the list of RICO offenses under state RICO. They've increased fines for hunting wild animals without permission. And then there is a new there's now a new definition for serious risk of substantial and irreversible impairment of a major bodily function and inevitable abortion as it relates to an affirmative defense for criminal abortion. I'm not sure how many of you are getting these criminal abortion cases. Public defenders typically don't, but just be aware of that change. All right, expunction cleanup. This was something that the public defenders worked on alongside with the TBI. If any of you have ever looked at the old expungement statute 4032-101, you know it was a complete nightmare. This bill sought not to actually change any of the content of the expungement statute, but just tried to clean up and make it a little bit easier to digest. So now what was previously 4032-101, it's now reorganized and split into lots of new parts. So 101, 106, 107, 108, 109, 110, and just kind of reorganized it to hopefully make it a little bit easier to digest, specifically hoping that people who are pro se trying to get expungements, maybe this will make it a little bit easier on them. But there are two substantive changes that were a result of this act. One, it just clarifies that the attempt, conspiracy, solicitation, or facilitation of any of the expungement eligible Class C felonies are also eligible, and that there's no opportunity for expungement for a person found not guilty by reason of insanity or incompetent to stand trial by a court in a criminal proceeding. So those were things that were already kind of implied, but were not actually clear in the law, but now are made very clear in the statute. All right, finally, this is the last section. I lied. I forgot about this section. This is the constitutional amendment section. You're going to be hearing a lot about this in the next year. because these are going to come up on the ballots. Because in Tennessee, this is the final stage. Voters have to agree to pass this. So the first constitutional amendment is the Victim Rights Amendment to the Tennessee Constitution. It's also referred to as Marsy's Law. It's a resolution that would amend Article 1, Section 35 of the Tennessee State Constitution by redefining what rights a victim has in Tennessee. So basically, it's like a victim's Bill of Rights, which, if y'all are familiar, that's already really in Tennessee statute. So this isn't really a huge change because this is actually already in TCA, but this would add it to the Tennessee State Constitution. I've been told that this is a national push by this billionaire whose sister was murdered. And he's trying to get this, I believe, in the federal constitution. And so, like I said, we kind of already had this in our code, so not probably a huge change here. But the big one, the big constitutional amendment you're going to be hearing a lot about is this bail constitutional amendment. And so this would amend Article 1, Section 15 of the Tennessee Constitution by further limiting the availability of bail. So currently, only a person charged with a capital offense is ineligible for bail, but this proposed amendment would remove the opportunity for bail for the following offenses: capital offense, act of terrorism, second-degree murder, aggravated rape of a child, aggravated rape, grave torture. And then here is the catch-all. Item 7 is the catch-all. Any other offense for which, as of November 3rd, 2026, a defendant, if convicted, could not be released prior to the expiration of at least 85% of the entire sentence imposed. So all of the 85% and 100% sentences as of the end basically of next year's legislative session are going to also be non-bailable offenses. So that is a huge, huge list. The bail industry is trying to fight this tooth and nail, but really at this point, it's going to be on the ballot. And so, just historically speaking, these things tend to pass once they're on the ballot. So I think that this is coming more likely than not. So just be aware of that. Now, the judge or magistrate has to place in the record the reason that the bail was granted or denied. And then there's language pertaining to habeas corpus. That is all unchanged by this amendment. All right, so sorry, y'all, I was trying to leave 5 minutes. I've left 3 minutes for questions, and I know that was a lot of content. So if you think of anything afterwards, my contact information is here. Feel free to email me. I'm always happy to answer questions over email if you have any.